Good afternoon, everyone. I'm extremely thrilled to be a part of this wonderful panel with these esteemed speakers. And today we are going to be speaking about white-collar crime investigation and landscape in India. We've seen a paradigm shift in the seriousness attached to white-collar crimes in India in the last decade and a half. And it's become a more serious and a more aware issue for investigative agencies today. So before we get to specific questions, I would like to have everyone's opening thoughts on the paradigm shift of white-collar crimes in the last one and a half decades in India. I'll start with Percy, sir.
Hi, so good to be here after a while. So I remember the resurgence of white-collar crime. So America always had this law which made corruption and graft illegal even if it was a crime committed in countries outside the US. So it had extraterritorial jurisdiction to that extent. Nobody really took that law very seriously until 9/11, and then the Bush administration found that a lot of terror financing, the source of terror financing was corruption and graft. They discovered how the terrorists were funded through Hawala, of all things, which we, of course, are very familiar with. And that began a new paradigm. So I remember sometime in 2003, I walked into the office of a New York law firm and they said, we would like you to meet our white-collar crime partners. And 7 or 8 people marched in, and I was wondering what the heck are these guys doing? And then it turned out that this had indeed become a very big issue in the US. In India, we followed suit. I think the first very big white-collar crime matter after Bofors, that is, was the Commonwealth Games. And believe you me, there are Commonwealth Games matters that are still going on. I just finished one last year. So, and it keeps going on. And then we have ED, which is a new law and which has been amended. And recently the Supreme Court in Vijay Madanlal's case has said that there are adequate safeguards in this law. So it has refused to strike down the law. This is the bird's eye view of where we are right now.
Your opening thoughts, Parvez?
Hello, everyone. So to take a cue from where Percy started, we have to go back to the history as to how this term white-collar crime was coined. It came through Sutherland when he first discussed white-collar crime in criminal law to mean that any crime or offense committed by a person who holds a position in office, who is involved in white-collar crime of a job, when he resorts to this kind of criminal activity, it is termed as white-collar crime. The paradigm shift that we have been seeing through decades, in the past few decades, more so with force of ED and CBI coming into picture, and various scams that you pick up a newspaper every day and you can see a scam there being discussed in the corridors of either the High Court or the Supreme Court. That's where we see today white-collar crime, that you are going through scams and scams and scams. To name a few, it started with the Satyam scam in India, if I'm not wrong, Percy. The first scam that I studied as a student when I was in law college was the Satyam scam, which had ramifications on Indian economy because it has shaken the stock exchange, though it, on the face of it, it was an accounting scam. So these kind of offenses which have a ramification effect on the society are termed majorly as white-collar crimes. The investigating agencies now enforcement agencies other than the local police stations are the CBI and the ED, which are majorly in picture. And off late that we are discussing here in Delhi is the liquor scam, where we all know that the Honorable Chief Minister was arrested and now he has let on interim bail. So I leave that question now to Bharat, if I may pass it on.
Yes, thank you, Mumtaz. Broadly, on just to share a few thoughts on white-collar crime, I mean, we all understand that it's very, very important to punish them, treat them differently. You know, a white-collar crime, just because we call it white-collar doesn't add some respectability that otherwise shouldn't be there. But it definitely needs a different approach. It's something that Justice Krishna Iyer famously called the subtle murders on the economy, and crimes that affect basically far more people than possibly traditional and conventional crime. But my problem is that have we gone too far in our enthusiasm of punishing white collar crime, or to be seen as punishing white collar crime? Have we gone too far? And I think in the course of discussion we'll be talking about it, how there are certain offenses which have been added now which have over criminalized or criminalize certain parts of doing business, how certain parts of white collar crime today, primarily the way some of the agencies have functioned, how the PMLA has panned out, how the Prevention of Corruption Act has panned out, raises some very, very disconcerting questions to me as a human rights lawyer, and I believe every criminal lawyer is a human rights lawyer first and foremost, and as a student of the Constitution. So definitely there have been some, if I take a bird's eye view over the past few decades, some very important developments where we've recognized certain areas of white collar crime as specific offenses like the PMLA. But maybe the pendulum has swung way too much in the opposite direction, where even, and we'll discuss it in the course of the discussion, that even innocent acts sometimes are seen as criminal. Sometimes acts of public servants and businesses in getting certain contracts we've seen were seen to be criminal, when ultimately on a trial nothing really came out. Grant of a tender, for instance, and this is a classic illustration on a grant of a tender where there was no competitive process. Even if there is no evidence of an illegal gratification or a bribery, was perceived as criminal back in the day, troubled a lot of people and certain economies and companies, but finally came out to nothing after a trial. So I think the focus today is on, and we have a number of these laws, the focus today is how do we introduce back the basic guarantees under the Constitution which are open to an accused or to the defense in terms of presumption of innocence, in terms of a right to bail, in terms of other protections against custodial torture and interrogation. Are we today in a position to ensure that they remain firmly in place and are not really ignored in our enthusiasm to treat white collar crime in a certain way?
From my perspective, I think we've been talking about white collar crime growing for the last 20 years. I feel corruption and white collar crime have been ingrained into India's history, political history, for a very, very long time. So it's not uncommon that bribery, corruption, these words have been thrown around for a very, very long time. What I believe there has been a paradigm shift in are a couple of things. I think one, the sophistication of the investigative agencies to deal with financial crimes has increased, and thus there's some amount of prominence regarding the prosecution themselves. The second piece around it, the people being prosecuted also have a certain amount of profile associated with them. I don't think by white collar crime we only talk about money laundering cases, which necessarily currently and more relevantly so is the focus of most of our conversations. Historically, customs cases were also white collar crime cases. Corruption cases have always been white collar crime cases. When people got cheated of their money by a contractor, by a contracting party, we had provisions in law already in place to deal with them. So what I believe there has been a systemic change in is lawyering around it. I don't think traditional criminal law, what we grew up learning as criminal law, is something that currently works, and we've had to redefine how we approach the law and how the regulators and the enforcing agencies approach the law with a lot more vigor, a lot more energy than they historically had while pursuing these type of cases. So I think on both sides there's a match, there's an obvious level up when it comes to the enforcement agency side, and I think there's something that we need to catch up as lawyers as well, that we need to push the boundaries and try to take it slightly beyond what the enforcement agencies bring to the table right now.
Thank you, everyone. Those were some interesting observations. PMLA is a 2002 act, and we are seeing its use more than ever in the last one decade, if not one decade, definitely the last half of the last decade. Why is this being invoked more than often? Percy, what are your views? Why do you think PMLA being a 2002 act, and like Samudra said, all these white collar crimes were always there. Why is PMLA now synonymous with a white collar crime, and why is almost every investigation leading to a repercussion under PMLA and arrest under PMLA? Because like you said, Vijay Madan Lal has actually made everything very, very stringent and strict for the accused, but with the Supreme Court carving out an exception for Arvind Kejriwal by granting interim bail for contesting elections on the ground that he's not a habitual offender. Does this actually become a flexible position where the courts are now going to go beyond the 3 conditions given under the Act and consider other factors while granting bail? What are your views on that?
Slightly extensive answer, so please bear with me, but I'll be very brief and to the point. So, everyone says about, talks about these 3 conditions. To my mind, it is a bunch of tripe and piffle. Okay, make no mistake about it. See, bail comes after arrest. Prior to arrest, the PMLA authorities, that is the ED, has to publish, or at least give to the accused the grounds of arrest. Now, unfortunately, as a matter of practice, they were not giving the grounds of arrest. And I think the accused were not even demanding this. There are a few instances where people said, how can you arrest me without giving me the ground of arrest? So then they started saying, well, okay, here's the ground of arrest. There's a little small para that doesn't say anything. Please remember that your 3 conditions of bail have to be in the context of the grounds of arrest. So you need a proper, extensive grounds of arrest so that you can prove. Now, in terms of the onus, the grounds of arrest have to show that the arresting officer has reason to believe guilt. As opposed to that, in 45, where the bail conditions are set out, the bar is still lower. It is reasonable grounds to believe that I am innocent. So if you have a proper grounds of arrest, and now recently we've had a judgment of the Supreme Court that says that grounds of arrest is compulsory. The difficulty is that they arrest the person and then they hand over the grounds of arrest, where the chap doesn't know what the hell is going on, and he signs it. Right, so I think our practices, see, the biggest difficulty in criminal law is that our practices are little antiquated and not too refined. If the prosecution follows proper practices, and this is the single biggest problem, the difficulty is not really with the law, and I think that is what Vijay Madanlal said. There are adequate safeguards over there. And as far as arrest is concerned, everyone who's arguing a bail, if the argument comes from the ED or if the judge poses an argument which is on fact, you simply have to say that is on fact. That will be proved in the trial. I am not supposed to answer that. I am supposed to answer you only on the grounds of arrest. That's it.
Bharat, since Percy sir has said there are adequate safeguards under the law itself, as a former judge, what is your view on the same? Because how do you see a statement made to a police different from a statement made to ED during the course of investigation? Because their admissibility is completely different. While a statement made to the police is not admissible, but a statement made to ED is during the course of investigation is treated like a judicial proceeding and it's admissible in law. So do you really think there are enough safeguards under the Act? And what are your views as a person who sat on both the sides? Let us have your views on that.
So I think on the question of adequate safeguards, I have a few concerns there. One that you rightly mentioned is that any statement given to the Enforcement Directorate is admissible in evidence. Now, of course, there are judgments that say that that cannot be the sole basis of a conviction under the law, and you'll need other evidences to corroborate that statement, right? But even the fact that it is admissible in the first place is very, very problematic. And I think the Supreme Court, in the case of Vijay Madanlal Chaudhary, decided that they are not quote-unquote police officers. And that's the test still under the law with 25 of the Evidence Act, where only a confession made to a police officer is inadmissible in evidence. And if the authority is not a quote-unquote police officer, it is still admissible in evidence. The reasoning in the judgment, and it's important to appreciate that critically, is that just because ED does not file what in law is known as a charge sheet, ED is not a police officer. So the test or the acid test remains that whether you are filing a charge sheet or not, does the case begin with an FIR and end in a charge sheet or not? So that technical issue. And ED, since it runs the case like a complaint, and ultimately it culminates into filing of a complaint before the court, which is obviously a deemed charge sheet in that sense, but it is still a complaint. So that distinction was kept in mind, but according to me and in my humble opinion, this is a distinction without a difference really. Because ultimately, whether it is a complaint or it is a charge sheet, whether there is an FIR or a complaint, the fact of the matter is a police officer is what the police officer does. The test is a substantive one. If you have the power to arrest, if you have the power to do a search, if you have the power to do a seizure, if you have a power to take a police interrogation or a custodial interrogation, then you have everything that a police officer does and then some more, right?
Don't file a charge sheet in 60 days, you get default bail.
You get default bail. So everything that the agency does is what a police officer does, and the safeguards are relatively less. So I think that needs to be examined. And if you look at Tufan Singh's judgment, when they drew that distinction in the case of the NCB investigating NDPS offences, Justice Nariman in that very beautifully written judgment said that NCB is a police officer. So therefore, every statement made to a NCB officer has to be thrown out and eschewed from consideration totally. So this is something that needs to be maybe re-examined on some day. And talking about safeguards, the fact that, and defense counsels on the panel would agree, and of the panel would agree with me, that if you're defending a PMLA case and you don't have a copy of the ECIR, which is the starting point of an ED investigation, that's also a big problem in itself. So you're arguing a bail, and you don't have a substance of what the allegation against you is. Now, of course, they'll start providing the grounds of arrest, but how detailed are those grounds? What is the application of mind? I mean, a reason to believe may be different for different people, right? I may find a reason to believe in pure conjecture and surmise, but it may not really be reason to believe on basis of substantive evidence. So that's problematic. I mean, you don't have a copy of what the case is against you when you're arguing bail. It's like being asked to swim with your hands behind your back. A defense counsel's position is very difficult today, especially with your reverse onuses, the higher threshold for bail. And to add to it, I mean, you don't have in the public domain today the ED manual which says how the ED is supposed to function in that sense. CBI manual has been out in the public domain, and it's been argued. Courts have tested the CBI's actions in how they've conducted investigations on the anvil of the CBI manual. You've done a search and seizure, you've not maintained the chain of custody, we'll check you on that, we'll check you on this. And the courts have gone on to say that if you've not abided by the CBI manual, which provides a number of safeguards over and above CRPC, then we'll check you, and it may also lead to disciplinary proceedings. But ED manual, on the other hand, is not supposed to be in the public domain and is not going to be in the public domain. So I don't think there are enough and many safeguards, with great respect, as far as PMLA cases are concerned, and maybe, and I think some of these are pending still before the larger bench, where even the Vijay Madan Lal conclusions are going to be retested. Let's hope that we'll have an act or an interpretation that would be more constitutionally compatible.
Just curious about thoughts on something from anyone on the panel. Do you think it matters that most statements that are now given to the CBI, ED, police, police less so, in CBI and ED offices happen under videography? So do you feel that because now we have a lot more access to witnesses being videographed while the statements are being given, possibly it's okay that these statements are admissible? It's something that I wanted to test some opinions on.
So I'll give my views first. I don't think it's an adequate safeguard, because if I am investigating somebody here and I'm telling him that this is your arrest memo, say this or I'm going to arrest you, I'm putting a camera in front of you, it doesn't make a difference at all. That's my view. I've done enough and more ED investigations, and I've had enough and more clients coming in telling us the kind of threat and pressure they are in. So I don't think just putting a video camera is going to solve anything. It's like telling a police official that, okay, video record everything that you're getting recorded from a person who's an accused. It just means the same. The only difference is maybe the ED will not use third degree, and the police may actually use third degree, but the threat of arrest will remain the same. And if you put a camera in front of them, it's not going to make a difference, because what you threaten them before you put the camera is what matters. That's my view. Percy, sir, any views on this?
I agree entirely, and I think Section 50, which Bharat referred to, is a problem, because any statement made to the ED officer is equivalent to a sworn statement before a magistrate, which is the normal norm in criminal jurisprudence. And I don't think videography really matters, because the person is already under a great deal of duress, and will make a deal with you, all that can happen. So I don't think that's really helpful at all.
Parvez, what is money laundering? Is it an offense on its own? Do you need a predicate offense? What is the threshold? Do you start making arrests under PMLA alleged suspicion of money laundering when the predicate offense is not even proved, when the charge sheet under the predicate offense is not filed. What do you understand from money laundering? It seems like ED is everywhere and white collar crime is all about ED now. What are your views on this?
Mumtaz, firstly, let me clarify. Money laundering is not just hawala transactions. Money laundering is a very complex subject. And ED, your question was a complex one. So ED cannot directly take cognizance of any offense until there is a scheduled or a predicate offense in place. That is number one. So scheduled offense is a must for ED to get into picture. The ECIR is registered only on the basis of a predicate offense, either by the local police station or through the CBI investigation that is going on. When in such investigation, money is the question which is to be investigated and the source of the crime is to be recovered, then the ED comes into picture under the PMLA Act. The act of money laundering, according to ED, is threefold. One is getting the money, placement, layering, and integration. Now, how this is done, I will explain through an example. So to give an example, say there is a person who's a white collar person with a job, say a principal of a college. Say his name is Joe. He is principal in the day and he deals in drugs in the night. So he supplies drugs to the students and other vocation of the college, and through that he collects the cash amount. Now that cash amount is the proceeds of crime. That proceeds of crime he deposits in banks through various channels and accounts in India. Then he layers that money through a complex web of sending it abroad to some shell companies that he may have some connections with. So he buys shares of those shell companies abroad. Then he forms companies in India where those shells company invest back into India, getting the money back. So now that money has come back to India through FDI, which is not drug money. So this is how money laundering takes place. So it is first placement of proceeds of crime into the system, then creating a complex web of sending it abroad, then getting it back into the system is majorly money laundering. So every money laundering is not just hawala transaction that you send cash abroad or get cash from abroad. It is a complex web that is created by this so-called conglomerates in these days, which are in, heavily into these scams and all, that money laundering comes into picture. ED comes into picture to investigate when there is a predicate offense. When they have to investigate the source of monies involved in that offenses, is all of this is investigated and gone into by the Enforcement Directorate, is my answer.
Thank you. Samudra, what is your take on corporate white collar crime? Is direct ocular evidence a material factor in corporate white collar crime?
I feel direct material evidence, right?
Yeah.
It would be a material factor.
Statement.
Statements,
Statements,
yeah. Direct material evidence would be a factor in all kinds of crime, and more so particularly I feel they take a special position in white collar crime, especially during the initial stages of an investigation. I think what we see from my experience, what I feel is the ED does investigate complex cases. It's document-heavy cases, not necessarily the simplest things to investigate, unearth, and reach and file a charge sheet in a way that it's understandable. What is a good starting point for an investigation is a statement. And probably the reason this question becomes relevant is surely the volume of approver statements we get to see these days, where somebody walks into the ED's office and gives their part of the story, which does incriminate a certain set of people. Now, given that the effect of this statement is that under the PMLA, you're naturally going to have a enlarged difficulty trying to get bail, because the law as it currently stands, and I personally don't blame Vijay Madan Lal for it, I blame the parliament, which forced the Supreme Court to give that constitutionality decision. But given that is the law as it currently stands, a statement cannot be proved or disproved, like Mr. Billimoria was saying, at a pre-trial stage. So it becomes material to understand that, yes, you're in the right way to investigate from an enforcement agency standpoint. It's wonderful to have direction to your investigation, and you can approach your investigation in a much more systematic manner. But from the legal standard of bail and what a statement places an accused in a predicament of, I think it's incredibly tough on a person to disprove a statement or prove it's false. But that said, I think it's entirely possible. I don't agree with the paradigm that bail is an impossibility in PMLA cases. It's tougher, sure. But that's exactly why, I mean, this was supposed to be for terror financing cases, right? Surely we've now evolved to reach a stage where it has acquired some amount of political notoriety. But for terror financing cases, you'd expect the standard of proof to be difficult, bail to be a lot more challenging and difficult. So I don't blame the law. I do understand it's going to be challenging to get bail. But from a purely evidentiary standpoint, this is a question that goes to the heart of an investigation. It helps the investigative agency. So yes, statement collection, I do agree. When you and I are as other than lawyers, as citizens, we are interested in seeing a prosecution agency reach the truth. And I think statement is a big part of it.
Thank you. Bharat, how important is mens rea in a white-collar crime? And with Samudra saying that, yes, bail is tougher, and the law is made that way, it's not an impossibility. Do you think putting bail at a higher threshold for a white-collar crime, which is called the crime of the elite, fair as compared to offenses of moral turpitude, where there are actual offenses against people, you call them offenses against human body, for example, an offense of murder. Is it, in your estimate, because like I said, you've sat on that side as well, is it fair to put a higher threshold of bail in a white-collar crime, like you said, which has ramifications on more number of people, as compared to an offense of moral turpitude? And how do you see the relevance of mens rea and motive in such cases?
Right. So the first part of the question first on mens rea. Now that's again something that is very, very disconcerting in a lot of ways. I understand over the years we've argued and advocated for strict liability offenses for some of these offenses. You know, it started with, for instance, kidnapping under the IPC is a strict liability offense. We started off with food adulteration related offenses. And then we've kept on adding to the list cases where you don't need to prove dishonesty or an ill intent when you are trying to prove the crime. Now, I understand in some cases it may be difficult for the prosecution agency to prove mens rea or a guilty intent, but at the same time, I don't think that justifies taking away that very, very important requirement. Now, if you look at PMLA now, with the definition of money laundering, there were certain parts, and the law has been amended a number of times, not getting into the minutiae of the language and how it has evolved. But ultimately today, I think very few people would disagree with me that on a reading of the definition of money laundering, even innocent people can be brought into the ambit of the section. Within the Vijay Madan Lal Chaudhary judgment also, there are indications and counter-indications, but broadly, the way the section has been interpreted, if you've had anything to do with proceeds of crime, and this may be an act of possessing, it may be an act of facilitating transfer, and even if you've not projected that proceeds of crime or that tainted wealth to be untainted wealth, which was the very idea of money laundering, if you look at how the offenses began and what were the first statutes on the issue, the very physical act of taking the money, as the name suggests, taking a tainted money and then laundering it and turning it into clean, white, authentic, legit money and portraying it as such to the formal economy and using it was the essence of the offense of money laundering, right? But now with the definition as it's structured currently, even if you've just possessed it, or if you've been an unwitting party in the entire assembly chain or the movement of proceeds of crime, for example, let me take this very extreme example of a chartered accountant or a lawyer accepting fees in a given case, and that fees may be disproportionate to his normal fees in a given situation, and you possess that proceeds of crime, even if you did not project it as untainted wealth and you knew it to be tainted and so on and so forth, the property may come into the ambit of proceeds of crime according to one construction at least, right? Because if you recall, the section 3 had a word and or, and an and has been read as an or and disjunctively. So ultimately, to cut the long story short, today even arguably a bona fide innocent third party may also be brought into the ambit of PMLA. You may not be able to secure a conviction. For the purpose of prosecution, you may proceed. Now this is very, very problematic to me as a student of the Constitution. I don't think there is a justification to go that far with mens rea has completely taken a back seat. You will have to remember what are the consequences. Consequences of a civil attachment may be very different, but here we are talking about lives and personal liberty. So again, on mens rea, that's broadly my take. On the issue of bail now, I think there's no taking away the fact that I think we are all speaking in one voice here that white collar crimes have to be looked at differently. PMLA has to be looked at differently. This is very problematic for the economy. This is very problematic for a number of reasons. But you may have that offense and you may have a very, very serious or a severe sentence for it, but is making bail that difficult with that higher threshold where the judge has to return a finding at the time of bail that I have reasonable grounds of believing that the person has not committed the offense. It's like abnormally high threshold, right? Having that higher threshold and denying people bail as a rule and granting it as an exception is not really the answer. I think it's the certainty of final punishment that would act as a better deterrent for people who are committing such crimes and who may be committing such crimes in the future. I think the certainty of punishment, a good sentence, a fair investigation, a speedy trial are all better deterrents than denying somebody bail at the time of investigation or trial. Because at the end of the day, there is a presumption of innocence. There is, some merit in the argument that the person may well turn out to be, because with the conviction rates, now ED obviously would argue that this is a better conviction rate than the others, but many of these trials have not seen their final stages yet, and we'll see in the next few years on how these trials pan out. But at the end of the day, have a more severe sentence, but certainty of punishment and not the denial of bail is the answer if we have to send out a strong message. Sorry for that very, very meandering answer.
Thank you, Bharat. Taking it on from there and just blending it with what Percy sir said, that you need to fight the bail on the grounds of arrest. Percy sir, would you then say that it's a far-fetched dream to apply for anticipatory bail, because then do we assume and proceed on a premise that it's illogical to apply for an anticipatory bail with respect to a white-collar crime? Because we also saw what happened with Arvind Kejriwal. He had filed an anticipatory bail and it was rejected. So if we blend these two views, what is your view? Should one actually even apply an anticipatory bail for a white-collar crime, or just wait for the grounds of arrest to be informed and then apply for regular bail?
So there have been situations where anticipatory bail has been granted in PMLA cases as well. The general difficulty with anticipatory bail is that if you do not get bail, if you look at the provision itself, the language of the section presupposes that you believe that you will be arrested. So if you do not get bail, then the police will immediately arrest you, even though they may not be planning to arrest you. Many times it happens that, we get to know that the cops are saying, who told you to apply for this? Because we were not planning to arrest you. But now that you've been rejected, we will have to arrest you.
The same happened with Arvind Kejriwal also. This was rejected and he was arrested the same day.
Arvind Kejriwal's case is on a completely different footing. He did not apply for bail. He was questioning the legality of his arrest. And that's one of the main points that I made, that look, there is a jurisprudence of bail. Why don't you follow that instead of questioning the legality of the arrest itself? Especially when you have pushed back on 8 summons. When he didn't answer the 9 summons, he was arrested. But the issue really is that today, the law being what it is, can any businessman of whatever standing, or can any common man refuse summons and say, please send me a questionnaire, I'll reply? I think that was a very cynical move on his part. And perhaps that is the reason that he was arrested. The issue really is that now the Supreme Court has thought it fit that given the election, there was a decision of Justice G.S. Singhvi in the PUCL case, where he said that democracy is one of the fundamental pillars of the Constitution, and free and fair elections is very important. And in the opinion of the Supreme Court, they believe that for a free and fair election, a leader from another party should be allowed to campaign. So I don't think it's a verdict either way. There's nobody who says that he was wrongly arrested, or that the courts will decide eventually. But I do believe that that decision was correct, because constitutional principles of what a democracy means have been upheld by the Supreme Court.
Thank you. So this is the law how it stands today. Um,
Kejriwal, he has never applied for anticipatory bail. What he applied for in the High Court was he has challenged issuance of summons against him, and he wanted that summons to be set aside.
but he
which
did
was-
argue for anticipatory bail in the same petition.
No. That petition was dismissed, and then he was arrested.
I can't comment on the case. I represent certain people, but he applied for anticipatory bail, got rejected,
Yeah,
got
that's what I
arrested, and then went to writ and to challenge it on
Yes,
instead
that
of
is what I
applying for bail.
understood. Yeah, that's why, because the moment he was arrested, he withdrew his petition from the Supreme Court because it was in line with what with the other lady's petition, that now that you are arrested, your anticipatory bail petition doesn't survive, so coming to Supreme Court does not make sense. Please apply for a regular bail, and that's why this petition from the Supreme Court was withdrawn.
That is right. He didn't
Yeah.
apply for bail.
Yeah,
That-
I'm
that
talking
part
about the
is right.
anticipatory
Yeah,
bail. Yeah, that he did. So now this is the current set of laws. Now, Parvez, what do you think is the impact of the upcoming law, which is the which is the future now? Because all this has been happening till now, and from July we are in a different world altogether. How do you think the new set of criminal laws will impact white collar crimes? Can I have your comments on that?
That's really interesting, Mumtaz, because we are at the threshold now. We are in June, I think we are in May, and 2 months here from we will have all 3 criminal laws in new form, which is BNS, BNSS, and BAS. So in few words, of course, there is not major change on white collar crimes as a subject in those new acts. But what the legislature has done in its wisdom is that the economic offenses which are defined under the IPC, erstwhile IPC, and the new BNS can also be now termed as organized crime offenses. So if an economic offender has committed the same offense twice, say even if it is a breach of trust or cheating offense, which he is a repeat offender, then the police can arrest you under the Organized Crime Act, under the BNS itself. So this is very stringent. That is a major change for white collar crime that I foresee. That at the inception, of course, there will be a lot many of interpretational issues which will go to the constitutional courts to seek it to be struck down as ultra-virus. But yeah, that is a problem. Plus, there is one section that has come to my mind from the BNSS is about bail. So under new section 479, which defines bail, there is a provision that after you complete 1/3 of your sentence, earlier it was half of your sentence that you are entitled for bail. Now it has been struck down to 1/3 of your sentence, but it is further qualified that that will not be applicable in case where there is one or more case pending against you. So the question to be asked here is that in a white collar crime, say in a PMLA offense, the ED cannot register an FIR without there being a predicate offense. So obviously there is an FIR, which is a CBI FIR or a local police station FIR, and then there is a ED ECIR. So does that mean that the provision of that 1/3 period undergone and entitlement of bail would invariably not apply to people who are being tried under the PMLA Act? Because there is more than one charge sheet, there is a predicate offense. The PMLA is the second offense. So how do we solve all of these anomalies? Only the time we'll have to see with it. But all said and done, the new set of laws, I don't see any major changes except of the fact that few of the redundant provisions of the IPC are done away with. I think there are 20 sections which have been repealed and 11 new are brought in. So only it is reshuffling of sections which we will have to look at. So even when we started practice, we used to carry the books along to refer to sections. Again, we will have to carry new books along to refer and compare to the old section with the new section. But of course, there's going to be a lot of confusion, not only on lawyers' side, I also foresee it at judges' side and at the enforcement agency side, because a lot of training will be required to see as to which law is to be applied. Plus, if I step into the shoe of an investigating officer, imagine a situation that the poor fellow has to also mug up the old laws, because not all cases have reached trial stages as of now. So this act will not have retrospective effect. So only those offenses which are committed post 1st of July would be tried under the new law, whereas those offenses which are pending trial, which are committed pre 1st July 2024, are to be tried under the erstwhile law, say IPC, CRPC, and evidence. So at such point of time, the officer who's running to the court will have to be abreast of both the set of laws, be it IPC, CRPC, and evidence, or be it BNS, BNSS, and BSA. So that is the difference that I see. Plus, the legislature has now brought in more tech-savvy investigation tactics into these new laws, where admissibility of evidence of electronically recorded evidence is admissible. The police officers are empowered to record the panchnamas or record statements on their mobiles or on video cameras, which would be admissible in law. So all of this, it will take some time to come to fore, because immediately trials are not going to begin. Though the offenses will be registered under the BNS from 1st July, the trials would begin only maybe after a year or two, and then we will have to see how they shape up in the courts of law.
Samudra, I remember you telling us about how cheating is also been always there, and it is a white collar crime, and we are just talking about PMLA all the time. Now with Parvez giving his comments on a repeat cheating offense, how do you see this panning out for corporates and for individuals in commercial contracts and tender contracts, where I know that there would be implications of Prevention of Corruption Act as well, but how do you see the stringency regarding a repeat offense of cheating disentitling a person from asking for bail?
From a corporate perspective, I think the source of the problem comes from an integrity pact that you enter into whenever you enter into any sort of government relations, government contracts, government tenders. In terms of cheating cases, if you have any sort of a disagreement with a counterparty on a commercial transaction, might result to a criminal case. But what I draw solace from, and before I even draw solace, let me immediately clarify and say that this is going to be complex. I am not sure how the jurisprudence around it develops, but surely if two employees of one company get arrested in 2001, get convicted, and another set of employees get convicted in 2024, now the company is potentially a repeat offender. I'm not sure if it's being tried in an individual capacity or it's only in the preceding tenure. So again, employee sets would determine whether you'd fall into the multiple category or not. But what I'm drawing solace from is I do see lesser and lesser convictions in 420 cases, especially on the corporate criminal liability side. There might be individual cases of cheating getting convictions, but on the corporate criminal liability side, there's no shortage of cases being filed. It's from my experience, mostly a good recovery tactic to have. But in terms of them reaching conviction, I think jurisprudence has reached some amount of progress that we may not have to worry about an innocent company falling prey to isolated instances of couple of convictions. If you see cases where there are multiple convictions, I think it points to a larger problem in the company. That's more on a practical side.
Just closing remarks from Bharat. What is your view on the impact of the new criminal laws on white collar crime, and are we creating a bigger demon in now making stringent conditions for bail, even for offenses like cheating? Are we a foot in the door or a foot back now? What do you have to say?
So some of this, but before I say that, I think I'm terribly upset personally because I've lost a lot of my bragging rights on the lighter side. You know, when a junior would ask us a problem on a CRPC, I'll tell him 167 subsection 2, third proviso. Now I can't do that anymore. These are different sections. But that aside, there's good and there's bad, okay? In some senses, it is the thin end of the wedge. I'll come to that. But number one, for instance, organized crime is an offense now under the IPC, the new IPC. And if you look at the definition of organized crime, a lot of things that are very, very vaguely worded and defined can lead to organized crime. For example, an organized crime used to be the MACOCAs, right? The Maharashtra Control of Organized Crime Act, which would apply on repeat offenders and crime syndicates and criminal organizations. Now a much wider, and we understand criminal law cannot by its very nature be vague and ambiguous, right? It potentially renders it unconstitutional. So the definition of organized crime under the new law is challengeable on the anvil of the Constitution, number one. Second thing that I'm not happy about personally is police custody after the first 15 days. There might be legitimate reasons for doing it in a case. For example, the accused gets arrested and gets himself lodged in a hospital for 15 days, thereby bypassing police custody. But barring those extreme cases, I think there wasn't a need of any police custody after the first 15 days. Now getting bail across the board would become more difficult because the IO can now seek police custody for 40 or 60 days, as the case may be, depending on the offense. In absentia trial is another big problem. Now we can not only try people, we can convict people in their absence. Now, again, something that has to be looked at, from the lens of the Constitution very strictly. The apparent rationale being that we've had a lot of problems extraditing people when they're only facing an investigation or facing trial. And now, since we can convict them in their absence, after recording evidence, it might become easier for us to get them, those fugitives, right? Not getting into the specifics of those cases. But I don't think that is going to be the case, because a trial held in absentia, whether a foreign authority or a country or the Department of Justice in a given country is going to accept your in absentia verdict of conviction and do extradition on that basis, a big question mark. Attachment proceedings under the new CRPC, very interesting. Now, investigating officer in a police station near you has powers equal to that of the Enforcement Directorate as far as attaching properties are concerned. Okay, can move an application before the magistrate, attach properties, and the kind of safeguards that we had in the PMLA on you going to the adjudicating authority, to the AT PMLA, all of those are missing as well. There are certain good things. I don't want to end on this is the last thing that I say, I promise. On search and seizure, and I'll end on a positive note, I'm not all cynical about this. Now, search and seizures are to be videographed. We had, as defense counsel, problems, in a murder case, the police would plant the weapon. Right? Now all these search and seizures and recoveries and disclosures shall be videographed is what the law says, okay? Now that shall may be treated as may or may not be. Police may say we have resource constraints and so on, but at least the law imposes a very positive duty on you to record these things so that there are less wrongful implications going forward. Mandatory forensics is a good thing. I personally feel that the law does a few good things. Doesn't go as far as it should have in certain other things. Certain other things we'll get to fight another day as constitutional lawyers in a court sometime.
Percy sir, any closing remarks on the way forward and how this is going to impact white-collar crimes, the new laws?
I haven't looked at the new laws at all. So I don't know. There is something that I put for the summer break. But I think as a closing remark, I just want to say that, look, we have to trust the judicial process. Unfortunately, in the current environment, what has happened is the bar is getting very increasingly fragmented. And both sides of the political divide, if there is a decision that they like, they say democracy wins. And if there's a decision they don't like, they say democracy is in danger. I think this is a very unfortunate situation, and I think lawyers have to be very careful not to get mixed up in this political narrative.
So we have no time for questions, and I think the panel was very clear, and I don't think there should be any questions. Thank you, everyone, and thank you for a very patient session.